Hello. We are going over the GCAAR sales contract. This is for the Greater Capital Area Association Realtors, and we are covering this contract covers Maryland, Montgomery County, and DC. So, as a quick note, right here at the top, just so all parties know, time is of the essence to all terms of this contract. So, what does that mean? If it says we have 5 days to do something, we have 5 days to do something. If we have 7 days, again, it's 7 days. So we're going to start off the contract. Let me just clean some stuff up here with today's date. When you click on it, calendar appears. Generally, you're dating this, whatever date you're writing your sales contract. And then the next line, you put in your buyer information, and the next line, your seller information. And these are going to be the parties who, among other things, confirm and acknowledge by their initials and signatures that by prior disclosure in this real estate transaction, and this first line is where you put the listing company. You can see it runs onto the next line in case you have a long name, and they represent the seller. Again, you can see right here, listing company who represents the seller. And the next line is the selling company. And generally, you're clicking the box for buyer, that the selling company represents the buyer. Very rarely are you going to check that second box that says seller. And that's for a thing called sub-agency, which is rarely practiced anymore. As we continue reading, the listing company and selling company are collectively referred to as broker. Again, if broker is acting as a dual representative for both parties, then the appropriate disclosure form is attached and made part of this contract. Remember, we always have to disclose who we represent. In consideration of the mutual promises and covenants set forth below, all other good and valuable consideration, the receipt and sufficiency of which is acknowledged, the parties agree to as follows. Basically, the parties are agreeing to move forward in good faith to the rest of the contract, which we're going to cover on the next roughly 7 pages. So number one, just like with any other contract you would fill out, we're putting the street address in. Let's say it's 123 Magnolia, M-A-G-N-O-L, Magnolia Street Northwest. There's a unit, we put that in. Now remember, with GCAAR, that can be used in Montgomery County, Maryland, or Washington, D.C. And you'll see that in just a couple seconds here. So this might be Washington, State, Washington, State, D.C., and it's probably 020002. If it is part of a condo or co-op, we're putting those names underneath it. And it's important to know if there is a parking space or if there is a storage unit. Sometimes there might be, many times there will be a legal description, and you're putting in the lot number, the block or square, or the section. All of that can be found on the tax records. If it's in a subdivision, again, we're putting the subdivision name and the tax account number, or also known as the tax ID. In DC, they call it tax account number, so that's why you're seeing tax account number. Part number two, we need to know where the property, again, is located and which addenda are going to be attached. Is it DC or is it Maryland? remember, this can be used for both again, Maryland and DC. The next section, number 3, is price and financing. So letter A is the sales price. Let's say it's $950. And now, with the newest 2026 changes to the GCAAR sales contract, you can put a dollar amount for the down payment or a percentage. So let's say we're putting 20% down and we're getting a first trust of 80%. The nice thing, your total financing will automatically add up at the bottom. Let's say, for example, just to show you, let's say we're putting 10% down and we're getting an 80-10. That financing automatically adds up to 90. But again, we're not doing that. We're just doing 20% down, 80% financing. And remember, you can put the dollar amount or the percentage. My recommendation, put the percentage. It makes it easier when you end up changing the price, if you end up changing the price. If we would change the price, we would cross out the 950, and then we would put, say, $1 million. And then again, that would be initialed. Letter D is the financing. We're making it contingent. Are we making it contingent on financing? Yes or no? Many times it will be yes. And then we're going to attach the appropriate financing addendum, which is going to be this next part right here. First deed of trust loan type shall be, and will it be conventional, or will it be VA, FHA, or is it going to be something else completely different? The next one, is it going to be contingent on an appraisal? Yes or no? And then the appropriate addendum will be attached. Now, the addendum is part of the financing, so we don't have to worry too much about that. Where a lot of agents mess it up is this second part right here. If no, seller will or will not provide appraiser with reasonable access for the appraisal, and buyer will proceed to settlement without regard to the appraisal. So, seller does not have to let the appraiser in if will not is checked. My recommendation, if we're waiving the appraisal, I still check will, just in case we want to have it appraised. Letter F is about assumption. And this is when you're assuming somebody else's loan. So, are you going to use this a lot? Probably not. But it's an option here for you. Assumption fee, if any, and all related charges to the assumption will be paid by buyer. If buyer assumes seller's loans, parties, again, will or will not obtain a release of the seller's liability to the financial institution or government, and parties will or will not obtain a substitution of the VA entitlement. These are important conversations to have with the listing. If you're the buyer agent and you're filling this out, important to have this conversation with the listing agent about the assumption, and especially if it is a government-backed loan or a VA loan. Balances of any assumed loan, secondary financing, and cash down payments are approximate. That final number is going to be given by the lender of who is holding the loan. Part number 4 is the deposit. And the first line is the amount. Let's say we're putting $50,000 down. And it will be held by, I'm going to pick on our partners here at Vesta Settlements, VSTA, and they are the escrow agent. This next line is very, very important. And its buyer has delivered or will deliver. Many times it would be will deliver. And then here we're putting a number of days. I usually say 5 days. Some people want 3 days. Some people want 2 days. Uh, again, that's negotiation between the buyer agent, well, the buyer and the seller. Now, notice in parentheses, if property is in Maryland and broker is an escrow agent, deposit must be delivered to escrow agent within 3 days of ratification. This is if the listing broker is holding the EMD. Remember, anytime a title company in Maryland is holding the EMD, there's a separate escrow agreement that must be filled out. As we continue reading here, should buyer fail to deliver deposit to escrow agent by deadline, buyer will be in default and seller may, at seller's option, deliver notice to buyer declaring the contract null and void. Upon delivery to buyer of seller notice to void, all respective rights and obligations of the party under this contract will terminate. Following the deposit deadline, but prior to seller delivery of notice to void, buyer may cure default by delivering to escrow agent, upon which all terms and conditions of the contract will remain in full force and effect. So what does this mean? Remember at the top of the contract, it said time is of the essence. Buyer has 5 days. Buyer has 5 days to deposit the EMD with Vesta Settlements in this situation, and I always like to say provide proof. Let's say it's day 6 or it's day 7, and the buyer has not delivered the EMD. Seller can terminate this contract. If, for example, it's day 6 and the seller is not voided, the buyer can still, again, cure the default by depositing the earnest money, and the contract is still in force. One of the things on the GCAAR sales contract, at the bottom, it is initialed by both the seller and the buyer on the bottom of each page. So make sure that you always have it initialed at the bottom. Going on to the rest of the deposit paragraph, deposit will be placed in escrow account of the escrow agent after the date of ratification in conformance with the laws and regulations of the appropriate jurisdiction. Remember Maryland or DC because it's GCAAR. And or if VA financing applies by Title 38 of the U.S. Code. This account may be interest bearing, and all parties waive any claim to interest resulting from the deposit. On the Maryland contract, it says it will be or will not be placed in interest-bearing account. The GCAAR one says it may be. Deposit will be held in escrow until, number 1, it's credited toward the purchase price. Or number 2, all parties have agreed in writing to its disposition. So maybe buyer and seller are splitting it. Maybe the seller is, they're agreeing that the seller is keeping it. Maybe the maybe the it's being maybe it's being released back to the buyer. It depends. Number 3, a court of competent jurisdiction orders disbursement and all appeal periods have expired, or it's been disposed of in another manner authorized by the law and regulation of the appropriate jurisdiction. Parties agree that the escrow agent will have no liability to any party on account of the disbursement of the deposit or on account of a failure to disperse the deposit, except in the event of the escrow agent's gross negligence or willful misconduct. So, cross your T's, dot your I's, and this is where the escrow agent, whoever's holding the EMD, the listing broker, or the title company, has some liability here. Paragraph 5, funds due at settlement. The balance of the funds due at settlement from buyer and or seller will be paid on or before the settlement date. Buyer and seller shall verify with settlement agent how funds due at settlement are paid. An assignment of funds will not be used without prior written consent of all parties to the transaction. So what does that mean? That means that, let's say the seller has a settlement in the morning on what they're selling and they're using it to buy in the afternoon. We need permission to do that. Number 6 is settlement. This is, again, I like to say our favorite day. We are going to double check the calendar. Usually 30-ish days. This is a conversation you have with the lender and the title agent. So July 24th is a Friday. My recommendation for settlement dates, Tuesday, Wednesday, Thursday. That's not saying you can't close on a Friday. It just makes it a little bit easier if there's a problem. Now, we know in a perfect world there are no problems and we can settle on Friday. Personally, I like Monday if possible, Tuesday, Wednesday, Thursday. I say Tuesday, Wednesday, Thursday are the best days. So again, we click on it, it auto-fills, and the next line, buyer selects, and we're going to put in here Vesta Settlements as the settlement agent, and they will be conducting settlement. Buyer agrees to contact settlement agent within 10 days after ratification to schedule settlement and place a title order. Many times it's us, the agent, that is setting up the contract with the title company, and the title company generally reaches out. We reach out. Just remember, as per the contract, it is 10 days for us to reach out. Technically 10 days for the buyer. I have an extra letter in Vesta. All right, paragraph 7. Except as otherwise specified herein, seller will deliver property at settlement, vacant, free and clear of trash and debris, broom clean, and is substantially the same physical condition to be determined as either the date of offer, the date of home inspection, or other. Personally, I always do date of offer. That way, whatever it looked like when we looked at it, it should look substantially the same. Excuse me. Now, we also have to have a conversation with our buyer. Hey, Mr. Buyer, the artwork is going to be off the walls. We don't know what's behind there. There's going to be possible flooring issues. I shouldn't say issues, but flooring discrepancies. If there was a couch or a heavy item, the carpet or floor might be a different color underneath where that item was. Failure to select an option in the preceding sentence shall be determined to be the date of offer. So if you miss a line, it's date of offer. Seller will have all utilities in service through settlement or is otherwise agreed. Seller will have smoke detectors and carbon monoxide detectors installed and operational prior to settlement in accordance with the requirements of the jurisdiction where the property is located. Parties will not hold broker liable for any breach of this paragraph. So basically, this is a buyer and seller paragraph. We, as the agent, we, as the broker, have nothing to do with it. The rest of the paragraph goes into home inspections. And the contract may be contingent on a home inspection or other inspections of the property. If buyer desires one or more contingencies, such contingencies must be included in an addendum. And we're filling out that the first box, it is contingent on a home inspection, or it is not contingent on a home inspection. Again, it depends on, are there multiple offers? It depends on how comfortable your buyer is. Except as otherwise specified above, the property, including electrical, plumbing, existing appliances, heating, air conditioning equipment, and fixtures shall be in as-is condition as of the date specified above. Neither broker and or the agents nor subagents are responsible for property defects. This is an area where we as agents can do better. This is maybe where we want to start talking about a home warranty. And again, there's a home warranty section down below in number 10. Number 8, access to property. Seller will provide broker, buyer, inspectors representing the buyer, and representative of lending institution for appraisal purposes and reasonable access to the property to comply with the contract. In addition, buyer and or broker, notice, and or broker, have the right to access the property to conduct a final walkthrough at a mutually agreed date and time within 5 days prior to settlement to confirm that it is pursuant to the maintenance and condition paragraph of the contract, which we just talked about, and if there are any repairs that they have been completed as agreed. Unless otherwise in writing, broker or licensee representing the broker must accompany during access. You can't just send your buyer, the broker or a licensee representing the broker. This could be the buyer agent, which in many cases it is. Sometimes it's another agent in the office that's accompanying the buyer through the home. So again, make sure that there's always somebody with the client while they're in the home. Paragraph 9, inclusions, exclusions. Again, there is a separate addendum, see defined and identified in the attached inclusions, exclusions, disclosure, and addendum. Always make sure that you have that. Paragraph 10, this is where we can select yes or no for the home warranty. And the second line, it's paid for and provided by either the buyer or the seller. Usually, if this is yes, it is checked that the seller costs not to exceed, again, it depends, $500-600, and who the warranty provider is going to be. Paragraph 11 is buyer representations. Buyer will or will not occupy the property as a principal residence. Unless specified in a written contingency, neither this contract nor the financing is dependent or contingent on the sale and settlement or lease of other real property. So this is what I like to call the mortgage fraud paragraph. We're confirming in the sales contract that it will or will not be a principal residence. Because again, the lending rates are different if it's a principal or an investment property. So many times, buyer will. But if you're working with a lender, or I'm sorry, investor, then it's going to be will not. In many cases. And again, it is not contingent on the sale or and settlement or lease of other real property. So there's no other reason for the buyer to back out. They don't have to settle on something else to get the money or move ahead. And the next one, the selling company is or is not, again, usually it's is, authorized to disclose to the listing company, seller, and any lender the appropriate financial or credit information statement provided to the selling company by buyer, also known as your pre-approval letter. Seller is relying upon all of buyer representations, including without limitation the accuracy of the financial or credit information given to seller, broker, or lender by buyer. Paragraph 12 goes over lead-based paint regulations. We know about 1978 and lead-based paint. So again, it's federal law, it's not us. Federal law requires sellers of properties built before 1978 to provide buyers with the required federal disclosure regarding lead-based paint. Again, GCAAR form and the EPA pamphlet, Protect Your Family from Lead in Your Home. In addition, for DC properties built before 78, sellers are required to use the GCAAR form lead paint DC disclosure. And for Maryland properties built for 78, sellers are required to provide buyers with the Maryland lead disclosure, excuse me, Maryland lead poisoning prevention program disclosure. A seller who fails to provide the required local and federal lead-based paint forms, including, notice, including the EPA pamphlet, may be liable under the law for 3 times the amount of damages and may be subject to both civil and criminal penalties. So if it's built before 78, make sure that you have the lead-based paint forms. Seller and any agent involved in the transaction are required to keep a copy of the forms for at least 6 years following the date of settlement. If a dwelling was built before 78 or if the building date is uncertain and the property is not exempt from the residential federal lead-based paint hazard reduction act of 1992, this contract is voidable by the buyer until buyer acknowledges receipt of the required federal lead-based paint form, including, notice, including the EPA pamphlet and the DC lead disclosure or Maryland lead disclosure if applicable, and has either taken the opportunity to incorporate a lead-based paint inspection contingency or waived such right. Until said acknowledgement occurs, buyer retains the right unconditionally and without risk of loss of deposit or adverse effects to declare this contract void. Parties have read and understood the provisions of this paragraph. So remember, it is important that we give both the lead-based paint disclosure, the federal one, the DC or Maryland one, and the EPA pamphlet. Remember, seller initials and buyer initials. And then we're also checking here that the lead-based paint form is attached, yes, or no, it's not attached, or it is not applicable. Again, very important because it can be 3 times the amount of penalties. Coming down here in accordance with the lead renovation, repair, repainting rule as adopted by the EPA, effective April 22nd, 2010, if the improvements on a property were built before 78, a contractor engaged by the seller to renovate, repair, paint the property must be certified by the EPA, or such work will disturb more than 6 square feet of lead-based paint per room for interior projects, more than 20 square feet of lead-based paint for any exterior project, or includes window replacement or demolition. Before and during any covered work, contractor must comply with all requirements of the renovation, repair, and painting rule. Note, here's the difference. A seller who personally performs any covered work on a rental property is required to be certified by the EPA prior to performing such covered work. No certification is required for a seller who performs covered work on the seller's principal residence. So if you're a seller and you're doing the work on your own, you're good. If it's on a rental property, you need to be EPA certified. However, notice down here, however, seller has the ultimate responsibility for the safety of seller's family or children while performing such covered work. For detailed information regarding renovation, repair, and painting, visit this website, and the parties again have read and understood the section. Again, initials. We're initialing these again if it's built before 1978. Paragraph 13 goes into the financing application. Notice it's bold and underlined. It's probably important. If this contract is contingent on financing, buyer will make written application for specified financing to any lender required, and any lender required property insurance no later than 7 days after the date of ratification. So the contract automatically puts in a 7-day time frame for the buyer to make application. Buyer grants permission for selling company, so again, buyer, agent, and lender to disclose to the listing company and seller general information about the progress of the loan application and the loan approval process. If buyer fails to settle, except due by default by seller, the provisions of the default paragraph shall apply, which we'll talk about later. Seller agrees to comply with reasonable lender requirements, except as otherwise provided by the lender required repairs paragraph of the applicable financing contingency addendum. So it depends which financing contingency we're using, and again, lender repairs. The other thing we want to talk about is insurance. Buyer is advised to consult with a property insurance agent before and immediately after ratifying a contract of sale. Obtaining property insurance is typically a lender requirement to secure financing. Property insurance has become difficult to secure in some cases. Availability, rates, premiums are determined in part by the number and nature of claims and inquiries made on a property, the condition of the property, as well as the number and nature of claims by the prospective buyer. So sometimes an insurance company will not insure a buyer. Sometimes they won't insure a property. So it's important to check this out as soon as we get under contract. And then remember down here, buyer initials. because this is important for the buyer to know. Paragraph 14 is a quick one. Damage or loss, the risk of loss or damage to the property by fire, force majeure, or other casualty remains with the seller until execution and delivery of the deed of conveyance to buyer at settlement, meaning the seller is responsible for the property until settlement. I've had properties in the past where it burned down 2 days before settlement, and that was a fun one. And again, it's the responsibility of the seller. The title paragraph, paragraph 15, is quite lengthy and it runs on to 2 pages here. So the title paragraph. The title report and survey, if required, many times if you're getting financing is required, will be ordered pursuant to the terms of the settlement paragraph, which we talked about above. If such report and survey are not available on the settlement date and were ordered as required, settlement may be delayed for up to 10 business days to obtain the title report and survey, after which date this contract, at the option of the seller, may be declared void, and deposit will be refunded in full to buyer. Fee simple title to property and everything that conveys with it will be sold free of liens except for any loans assumed by the buyer. So sellers agreeing to pay everything off and pass the title free and clear. Title is to be good of record, marketable, and insurable by a licensed title company with no additional risk premium. Title will be subject to any easements, covenants, and conditions and restrictions of record in existence as of the date of ratification. So if it's a condo, we know that there's a condo easement, a condo covenant. If there's an easement, we know that on the date of ratification. If, as determined by the settlement agent, title is not in the required condition by settlement date, said date shall, I'm going to extend this out here, automatically be extended 30 days, and seller shall promptly take all action necessary to place title in the required condition prior thereto at seller's expense. If title is not in the required condition by extended settlement date, then buyer may deliver notice to seller declaring the contract void. So if there's a problem on the title and we can't go to settlement, it automatically extends 30 days. And seller needs to work on fixing the title. Otherwise, by the time the extended settlement date, buyer can declare the agreement null and void and move on to something else. Now, as we continue here, broker or any other agent, sub-agents, or employees of the broker and settlement agent are not advising parties to certain issues, including but not limited to, and again, stuff we've heard before. Land use, lot size, exact location, and possible restrictions of the use of the property due to restrictive covenants, easements, zoning, subdivision, or environmental laws. Broker or agents and settlement agent are hereby expressly released from all liability for damages by any reason of any defect in the title. Basically, You are not an expert on land use. You are not an expert on use restrictions. You are not an expert on restrictive covenants. You are not an expert on zoning. And you and the settlement agent have no liability if there's a defect in the title. I hate to say it, that's a seller problem. The next paragraph starts out for the buyer. The manner of taking title may have significant legal and tax consequences. Buyer is advised to seek the appropriate professional advice concerning the matter of taking title. Seller will convey the property by special warranty deed or personal representative deed in the event of a decedent's estate, meaning somebody died. Seller will sign such affidavits, lien waivers, tax certifications, and other documents as may be required by the lender, title insurance company, settlement agent, or government authority, and authorizes settlement agent to obtain payoff or assumption information from any existing lenders. So again, the seller is agreeing to work with the title company for payoff statements. The special warranty deed is what they use in Maryland and DC. Side note, also used in Pennsylvania. Virginia uses a general warranty deed. It's just different types of deeds and protections. Unless otherwise agreed in writing, seller will pay any governmental special assessments and will comply with all orders or notices of violations of any county or local authority, condo unit association, and or homeowner association, or actions in any court on account thereof against or affecting the property on settlement date. The parties authorize and direct settlement agent to provide a copy of the combined settlement statement to the seller, buyer, listing company, selling company, homeowner condo association, reload company, and or any third party payees reflected on the settlement statement. So again, buyer and seller agree that everyone can get a copy of the settlement statement. Under certain circumstances, when a property is substantially renovated or modified, or its usage is changed, a certificate of occupancy or final inspection certification may be required prior to use and occupancy of the property. Additional information can be found here for DC, and again, this bottom link for Maryland, Montgomery County. In the event of the local authorities requiring the issuance of a certificate of occupancy or final inspection, the seller agrees to provide evidence thereof. Again, something changed, or again, we need a certificate of occupancy. Seller agrees to work with us to get it. Paragraph 16 is about possession date. And possession date isn't always the settlement date. Many times it is, but sometimes it is not. Possession date, unless agreed to in writing between the parties, seller will give possession of the property at settlement, including delivery of keys, fobs, codes, if any. Notice the if any part. If the seller never had a mailbox key, they're not required to get one. If they have a key for the back door but not the front door, they give what they can. If seller fails to do so and occupies the property beyond settlement, seller will be a tenant at sufferance of the buyer and expressly waives all notice to quit as provided by law. Buyer will have the right to proceed by any legal means available to obtain possession of the property. Seller will pay damages and costs incurred by buyer, including reasonable legal expenses. So this is when a seller stays beyond the possession date, sometimes in an extended settlement. Um, the buyer then becomes the owner and theoretically the landlord and can throw the seller out. Fees. Fees for preparation of the deed. That portion of the settlement agent's fee billed to seller. Cost of releasing existing encumbrances, seller's legal fees, and other charges assessed to the seller will be paid by the seller. Fees for the title exam, survey, recording, and that portion of the settlement agent's fee billed to the buyer, buyer's legal fees, and any other proper charges assessed to the buyer will be paid by the buyer. Fees will be reasonable and customary for the jurisdiction where the property is located. Recording and transfer fees are covered in an appropriate jurisdictional addendum. It breaks down basically who's paying what. Deed prep and the settlement agent fees for the seller, cost of releasing loans, seller legal fees paid by the seller. The buyer's title exam, title insurance, survey, buyer's legal fees paid by the buyer. Broker compensation. Parties irrevocably instruct settlement agent to pay listing broker compensation and or buyer broker compensation at settlement as set forth in the parties' respective brokerage representation agreements and this contract. So they're allowing us to get paid. Paragraph 19 talks about adjustments. Pro-ratable charges, including but not limited to rents, taxes, and sewer charges, front foot benefit, and house connection charges, condo co-op, unit owner association, or homeowner periodic assessments are to be adjusted to the settlement date. So taxes will be prorated, HOA fee prorated, rent, water, sewer, all that will be prorated. Any heating or cooking fuels remained in supply tanks at settlement will become property of the buyer. Back in the day, we used to figure out how much, say, propane there was in the tank and figure out the cost of propane, and the buyer would pay the seller. Now it's just included. Taxes are to be adjusted according to the information provided by the collector of taxes. And if a loan is assumed, interest will be adjusted to the settlement date. End buyer will reimburse seller for any existing escrow accounts. So if there's a tax and insurance escrow account, buyer's reimbursing the seller. Paragraph 20 talks about disputes. In the event of any dispute between seller and broker and or buyer and broker, resulting in broker or agents or employees of broker being made a party to such dispute, including but not limited to litigation, arbitration, complaint, and claim before the applicable real estate commission, whether as defendant, cross-defendant, third-party defendant, or respondent. Seller and buyer jointly and severally agree to indemnify and hold broker and any agents, etc., harmless from any liability, cost, damage, or expense limited to but not including to filing fees, service processing fees, transcript fees, legal expenses, etc. Resulting therefrom, provided that such dispute does not result in a judgment or decision against broker, broker's agents, subagents, or employees for acting improperly. So again, we can be made part of any of these things. It's important to cross your T's and dot your I's. Paragraph 21 is where we go into legal expenses, and it goes on to the next page. In any action or proceeding between parties based in whole or part upon the performance or non-performance of the terms and conditions of the contract, including but not limited to breach of contract, negligence, misrepresentation, or fraud, the prevailing party in such action or proceeding will be entitled to receive notice reasonable legal expenses from the other party as determined by the court or administrator. So it's always important to remind our client reasonable legal expenses. And the second part of that paragraph, in the event a dispute arises resulting in broker and or settlement agent being made party to the litigation by parties, the party who brought the broker or settlement agent into the litigation shall indemnify broker and settlement agent for all legal expenses incurred unless the litigation results in a judgment against the broker or settlement agent. So we're good unless a judgment is brought before us. Paragraph 22, performance. Delivery of the required funds and executed documents to the settlement agent will constitute sufficient tender of performance, meaning that they performed. Funds from the transaction at settlement may be used to pay off existing liens and encumbrances, including interest as required by lender or lien holder. So, everybody needs to get copies of signed documents, including the settlement agent, especially when there's funds involved, and the settlement agent will use funds to pay off any existing liens. Paragraph 23, again, is important. Sellers shall keep existing mortgages free of default through settlement. All violations of requirements noted or issued by any government authority or actions in any court on account thereof, against or affecting the property at settlement, shall be complied with by seller and the property conveyed free thereof. Meaning the seller will clear any issues at settlement for violations, etc. Paragraph 24, again, is important. Defaults. It's bolded. Parties agree to perform at settlement in accordance with the terms of the contract. Failure to do so constitutes a breach. If buyer fails to complete settlement for any reason other than default by seller, at the option seller, the deposit may be forfeited as liquidated damages, not penalty, in which the buyer will be relieved from further liability to the seller. Excuse me. If seller does not elect to accept the deposit as liquidated damages, the deposit may not limit the buyer's liability in the event of a default, also known as the buyer could be sued. If deposit is forfeited, or if there is an award of damages by a court or compromise agreement between the parties, listing company may accept, and seller agrees to pay listing company 1/2 of the deposit in lieu of the listing broker compensation, provided listing broker's company share of any forfeited deposit will not exceed the amount due under the listing agreement. So, if a buyer defaults, listing company can accept and seller agrees to pay 1/2 of the deposit. Now we go to the second paragraph here. If seller fails to perform or comply with any terms of the contract or fails to complete settlement for any reason other than default by buyer, buyer will have the right to pursue all legal or equitable remedies, including specific performance and or damages. What that means is the buyer can sue the seller to sell the property. If either seller or buyer refuses to execute a release of deposit, when requested to do so in writing, and a court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including without limitation, reasonable legal expenses incurred by the other party to the litigation. Escrow agent will have no liability on any party on account of the disbursement of the deposit or on account of failure to disperse the deposit, except in the event of escrow agent's gross negligence or misconduct. Escrow agent will not be liable for the failure of any depository in which the deposit is placed, and parties shall indemnify, defend, save harmless the escrow agent from any loss or expense arising from the holding, disbursement, or failure to disperse the deposit in which, again, the escrow agent is in default. So it's important to know that the party should release, and if they don't, they could end up paying reasonable legal expenses. If either the buyer or seller is in default, then in addition to other damages, the defaulting party will immediately pay the broker compensation in full, as well as the cost incurred for the title exam, appraisal, and survey. So let's make sure that they don't default. Paragraph 25, disclosure to the parties. Again, this is a unique DC thing in Maryland. Parties should carefully read this contract to be sure that the terms accurately express their understanding as to their intentions and agreements. By signing this contract, parties have not relied on any representation made by brokers, agents, subagents, etc., except those representations expressly set forth in this contract. Further, brokers or any agents, subagents, etc., settlement agent do not assume any responsibility for the performance of this contract by any and all parties hereto. Broker can counsel on real estate matters, but if legal advice is desired by either party, such party is advised to seek legal counsel. Parties are further advised to seek appropriate professional advice concerning the condition of the property and or tax and insurance matters. Again, you are not an attorney. You are not a tax expert. You're not a home inspector. So do not advise on matters that you are not part of. You are a real estate agent. You are a realtor. You can advise on real estate matters. The following provisions disclose some matters which the parties may investigate further. These disclosures are not intended to create a contingency. Any contingency must be specified by adding the appropriate terms to the contract. As I like to say, there's a form for that. Broker or any agent, subagent, employee, settlement agent make no representations or assume any responsibility with respect to the following. And letter A is property condition. Various inspection services and home warranty insurance programs are available. We're advising the client basically to do their inspection as they wish, to get that home warranty as they wish. Brokers not advising the parties as to certain other issues, including but not limited to condition of real or personal property, water quality and quantity, sewer on-site sewage disposal systems, septic systems, public utilities, soil condition, flood hazard areas, airport or aircraft noise, roads or highways, and construction materials and or hazardous materials without limitation, flame retardant treated plywood, radon, urea foam, formaldehyde insulation, mold, polybutylene pipes, and synthetic stucco, underground storage tank, defective Chinese drywall, asbestos, and lead-based paint. Information relating to these issues may be available from appropriate government authorities. All of these things over the years have been issues, have caused health issues in people. And again, we don't know unless we know, but generally we don't. B, legal requirements. All contracts for the sale of property must be in writing to be enforceable. Upon ratification and delivery, this contract is legally binding. Any changes must be made in writing, agreed to by all parties to the contract, and delivered to all parties for the changes to be enforceable. Remember, there needs to be delivery. The buyer needs to have it delivered to them. The seller needs to have it delivered to them. Letter C is financing. Mortgage rates and associated charges vary with financial institutions in the marketplace. Buyer has the opportunity to select a lender and the right to negotiate terms and conditions of financing. Paragraph D, broker. Broker is being retained solely as a real estate agent and not, I'm going to underline that again, not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, mold, or air quality expert, home inspector, or other professional provider. Broker may from time to time engage in the general issuance, title, insurance, mortgage, loan, real estate settlement, home warranty, and other real estate related business and services. Therefore, in addition to broker's compensation, broker may receive compensation related to other services provided in the course of this transaction pursuant to terms of a separate agreement. This is why it's important that we give clients the Palladian title disclosure, the vested disclosure. If you're getting money, it's always important to disclose if we have the office has an ownership in something else. E, property taxes. And this is something that not everyone thinks about. The property tax bill could substantially increase following settlement. Remember, because the property could be selling for more than what it's assessed at. For more information on property taxes, contact the appropriate taxing authority in the jurisdiction. And F, title insurance. Buyer may, at buyer's expense, purchase owner's title insurance. Again, this is separate. This is owner's title insurance. The coverage afforded by such title insurance would be governed by the terms and conditions thereof, and the premium for obtaining such title insurance coverage will be determined by the extent of the coverage. So it depends what type of coverage you're purchasing. Buyer may purchase title insurance at either the standard or enhanced coverage and rates. For the purpose of owner's policy premium rate disclosure by buyer's lender, if any, and settlement agent, parties require that enhanced rate be quoted. Buyer understands that nothing obligates them to get owner's title insurance at any time, including settlement, and the availability of enhanced coverage is subject to underwriting. So it's always a conversation I have with clients. Generally, the title company has it. I always recommend getting the owner's title insurance policy. It protects the owner as the amount of the loan goes down. Assignability of this contract may not be assigned without the written consent of the parties. If parties agree to an assignment, the original parties to the contract remain obligated. So it goes back with the original parties. Paragraph 27 is one of my favorites just to say, FERPTA. the Foreign Investment of Real Property Tax Act. This came about in 1986. And interesting to note, a buyer of residential real property located in the United States must withhold federal income taxes from the payment of the purchase price if the purchase price exceeds 300,000 pounds, or the purchase price is less than or equal to $300,000, and the property will not be owner occupied. And the seller is a foreign purposes for the purposes of U.S. income taxation. A foreign person includes, but is not limited to, a non-resident alien, foreign corporation, foreign partnership, foreign trust, or foreign estate. In the event seller is a foreign person as described above, seller will be subject to the withholding provisions of FIRPTA. If seller is not a foreign person, seller agrees to execute an affidavit to this effect at settlement. There can be significant withholding. Again, you can see from the amount of money here, significant withholding from the seller and possibly paid by the buyer. So it's important to have that conversation at listing and ratification if the seller is FIRPTA. Paragraph 28 goes over some definitions of the contract. So it defines appraisal as a written appraised valuation. Days, I always like to point it out, are calendar days. Sunday, Monday, Tuesday, Wednesday, Thursday, Friday, Saturday. Business days are Monday through Friday, excluding federal holidays. D is important. For the purpose of computing time periods, the first day will be the day following delivery, and the time period will end at 6 p.m. on the day specified. Maryland contracts are 11:59:59 p.m. These GCAAR contracts are 6 p.m. and VAR Northern Virginia are 9 p.m. So it's important to know our date and time frame. For the purpose of review periods related to the resale package required to be delivered from seller to buyer, the first day will be the day following delivery, and the time period for that will be 11:59:59. So most documents are 6 p.m. except HOA, condo, co-op docs. That's 11:59:59. Remember, the day you get it, it's day 0. The next day is day 1. If settlement falls on a Saturday, Sunday, or legal holiday, then it is the prior business day. If date of ratification, this contract shall be deemed ratified when the contract, all addenda modifications have been signed and initialed where required by all parties and delivered to the other party pursuant to the notices paragraph, which is the next one. Singular includes the plural. Legal expenses mean attorneys' fees, court costs, and litigation expenses, including but not limited to expert witness fees and court reporter fees. Specified financing is the financing that the buyer is applying for. And the resale package are the documents, statements, or instruments required to be delivered from the seller to buyer per the HOA, condo, or co-op. So it's important to read and go over these definitions and know your time frames. Paragraph 29 is notices and delivery. A notice is unilateral communication from one party to another. All notices required under this contract will be in writing. So again, notices need to be in writing. Notices to seller shall be effective when delivered to seller or seller's agent or that agent's supervising manager. Notices to buyer shall be effective when delivered to buyer or buyer's agent or their supervising manager. So when it is delivered to the seller or their agent, so when the agent knows, the seller knows, or the buyer knows. Delivery means sent or wired by electronic medium, which produces a tangible record of the transmission, such as fax or email. Hand carried, sent by overnight service or U.S. postal mailing. In the event of an overnight delivery service, delivery will be the next business day following the sending, unless earlier receipt is acknowledged in writing. In the event of U.S. postal mailing, delivery will be on the third business day following the mailing, unless earlier receipt is acknowledged. So I'm overnighting something on Tuesday. They were counting Wednesday as the delivery. I mail something on Tuesday, Wednesday, Thursday, Friday is USPS third business day delivery. Delivery of the resale package must be made directly to buyer. Delivering it to a buyer agent does not constitute delivery from seller to buyer. The resale package must be made directly to the buyer. Now, it could go to the buyer and the agent, but must be to the buyer. Resale package may be delivered to seller or seller's agent through an electronic link provided by a management association for purposes of delivery, as may be required in separate addendum. Miscellaneous contract may be signed in one or more counterparts, each of which is deemed to be original and all which together constitute one and the same instrument. We really don't have that problem anymore with electronic signatures. But back in the day, the buyer husband could sign one, the buyer wife could sign one, and then seller could sign one. As long as everything matched, we're good. Now, again, we have documents obtained via fax or PDF attachment to an email will also be originals. We also have electronic signatures. This is important. Typewritten or handwritten provisions included in the contract will supersede all pre-printed provisions that are in conflict. So if you write anything, excuse me, or cross it out and handwrite it, that's what sticks. Paragraph 31, if this contract becomes void and of no further force and effect without default by either party, both parties will immediately execute a release, directing the deposit to be refunded in full to buyer according to the deposit terms. And the last part here, 32, entire agreement. This contract will be binding upon the parties and each of their respective heirs, executors, administrators, successors, and permitted assigns. The provisions not satisfied at settlement will survive delivery of the deed and not be merged herein. This contract, unless amended in writing, contains the final and entire agreement of the parties, and the parties will not be bound by any terms, conditions, oral statements, warranties, or representations contained herein. The interpretations of this contract will be governed by the laws of the jurisdiction where the property is located. So if you're in DC, the DC laws apply. If you're in Montgomery County, Maryland, the Maryland laws apply. Remember, any changes need to be initialed and dated. As we continue down, seller signs it, buyer signs it. The last person puts in the date of ratification here, seller's information, buyer's information, and then finally, at the bottom, the listing office information, the agent information, etc. Always make sure that you fill out this bottom portion, even though it says for informational purposes only. It is very important that this is filled out because this is what the title company sees, the buyer broker, the selling broker, um, and the lender as part of the contract. And that concludes the GCAAR, Greater Capital Area Association of Realtors sales contract.